me? Court calls the case of the people versus Dana Fletcher.
That's those two people.
Attorney Mark McManus on behalf of Dana Fletcher. Speak your name.
Dana Fletcher.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor. There has been an amended complaint. I'm not sure if we have to do that first before the plea.
Well, hold on.
Oh, we did it last.
I thought we did it last time where there was a what?
It was filed with us after.
It was filed after the last hearing.
Yes.
All right. And so that's the count 3, which is the operating while intoxicated second offense. Counsel, as to the arraignment on that, your client waives formal reading and stand.
He does, Your Honor. Thank you. Yes.
All right. And so court will enter a not guilty plea as to that added count 3. But that means, hold on a second.
Count 2 was deleted.
Count 2 was deleted, but count 2 was the operating while intoxicated. I just want to make sure that his bond conditions match a drinking and driving offense, but I think they do.
They do, Your Honor.
All right. Very good. All right. So now we have that. The plea form indicates that the defendant will be pleading to count 3, the operating while intoxicated second offense, the 1-year offense, and an added count 4 of use of a controlled substance, that being fentanyl, the 1-year offense. Upon a successful plea to those charges, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct, counsel?
It is, Your Honor.
All right, very good. Sir, if you can please raise your right hand to be sworn.
Speak loud.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again, please, sir.
Dana Fletcher.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 misdemeanor charges. The first being the stated count 3 of operating while intoxicated second offense. That's a misdemeanor punishable by up to 5 days to 1 year in jail, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
The other charge, the added count 4 of use of a controlled substance, that's a misdemeanor punishable by up to 1 year, a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Understand that?
Yes, Your Honor.
Understanding all of that, to the charge of operating while intoxicated second offense, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
If you see a copy, looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rank.
Yes, sir.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
On the date of December 31st, 2023, at the location of US 23 near Nixon Road in Ann Arbor Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, Your Honor.
And what had you ingested, sir?
Fentanyl.
All right. And did you know that what you were ingesting was fentanyl?
Yes, Your Honor.
All right. Were you stopped by the police at some point?
Yes, Your Honor.
All right. Why'd they stop you?
Speed.
Speed.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes. Yes.
All right. Did the results of that blood draw show the presence of fentanyl and or its derivative in your system?
Yes, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted on or about, January 20th, 2021 in Bowling Green, Ohio of the offense of operating under the influence of alcohol or drugs?
Yes, Your Honor.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Yes, sir.
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
We are satisfied, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Count 1 is dismissed. Pre-sentence investigation and report and screening and assessment is hereby ordered at 14A2 probation. Sentencing in this matter will be May 26, 2026, 10 a.m. before Judge Barr.
Thank you very much, Your Honor.
Thank you. Bond with its conditions will continue. Thank you.
Thank you very much, Your Honor.
Court calls case of the people versus Desmond Hodge.
Good afternoon, Your Honor. Raymond Cook.
Hello.
Good afternoon, Your Honor. James Feifelsky appearing with and on behalf of Hodge, who is approaching. You state your name, please.
Desmond Hodge. Oh, wait, wait.
Judge, I believe all discovery is in. To the best of my knowledge, we'd ask the court to set this for a preliminary exam.
And Your Honor, apologies, I sent 2 emails yesterday. One of them, I initially thought there was no additional discovery. The agency got back to me and said, actually, it was under a different case number. So there may be additional video that has not been marked yet. I only just got that video. I don't know if it's for this case or if it was for a different case because I haven't had the opportunity to watch it yet. It's a couple hours long, but there may be more discovery that still needs to get sent.
If the court can set this out, we're comfortable moving forward with what we have, understanding if there is additional discovery, it'd probably show up within the next week or so.
Hopefully, we begin. There's about 4 hours and I do start a trial Monday next week. So with that.
There's 4, you think there's 4 hours of video?
That's why I saw on the timestamps at evans.com. There was numerous videos. I added it up quickly.
All right, I'm going to adjourn the probable cause. Let's get the discovery and if there's 4 hours of video, then I at least have to look at it. I'm going to adjourn it out to May 14, 2026, 9 a.m.
Your Honor, I am seeing that I believe my client has a review hearing. Well, if it's later in the morning or 12:30, it'll work. He's got a review on a case that arose from the same date and time in 14B, for which he's on probation. That's at 10 o'clock, so I think we'll be okay.
For this gentleman?
Yes, Mr. Hodge.
Okay, so theoretically, unless you had somebody in custody, you're going to be in this block, so he shouldn't be
That will
14B that long and be able to get over.
that'll work out perfectly. Okay. Thank you.
All right, thank you, sir.